Thanks very much. It's a pleasure to be here. Thanks very much for the invitation and to all the organisers for their hard work in organising this excellent event. And I'd just like to extend my gratitude to be at an event that's honouring my late colleague, Dr. Vicky Conway, who we all still very much miss at DCU. I'm also honoured to share the stage with Maeve and Phil Scraton, who have contributed so much in their careers to the cause of justice and highlighted in fresh ways the need for innovative justice techniques to ensure truth is spoken to power and effective action is taken. On these islands, we are all in your debt for your work on Hillsborough, on the Magdalen Laundries, mother and baby homes, and most recently your shared work on the Truth Recovery Design Panel. I'm conscious today that this conference is taking place at a time when there are particular challenges facing those who wish to address widespread and systemic human rights abuses. Recent European and local elections evidence the rise of far-right politics around the world, in the European continent, and the November presidential election in the US probably offers further cause for alarm. Dealing with the violent past raises questions of national identity, of responsibility, and it challenges and disrupts national and social myths of innocence, of an exceptional nation, and as violence as an aberration. Resistance to dealing with the past is therefore to be expected. And so today's presentation is designed, there we go. No. There we go. We're changing? No? No. Oh, God, lovely, thanks. Today's presentation is designed to take stock of how we've been dealing with the past on the island of Ireland, to look briefly at some comparative perspectives, but to really focus on the hitherto neglected role of power in transitional justice dynamics, particularly related to non-recent institutional abuses. And I want to extend that analysis to look at the question of the role of power in proposals for co-design of mechanisms to deal with the past. So whatever else we can say about the island of Ireland, we haven't been idle when it comes to mechanisms to address the non-recent past regarding institutional abuses. There's been several inquiries, redress mechanisms and apologies. The apologies listed there are only the state ones, with several apologies coming from religious organisations as well. The state in Ireland and in Northern Ireland and the taxpayer has spent significant sums of money for these processes, but as we perhaps are already aware, rates of survivor satisfaction, vindication and validation are often low or lacking altogether. In 2024, the issue of dealing with the past is not going away, rather it's expanding into new contexts and territories. As the work of the independent panel that Maeve and Phil proposed is ongoing, it combines with the establishment of a tribunal of inquiry regarding abuse within the Irish Defence Forces after advocacy from the Women of Honour. A scoping inquiry regarding sexual abuse in religious day schools is due to report this year, and the payment scheme for mother and baby homes institutions has commenced, with reports in the press last week of a mere 371 survivors deemed eligible of 3,600 having access to the service to date. We also know that there's much more to do based on existing survivor advocacy and the work of academics and others. Psychiatric hospitals in the Republic of Ireland, clerical abuse in Northern Ireland, abuse within non-residential schools in Northern Ireland, boarding out and foster care in both institutions, illegal adoptions and cross-border elements to these offences and the already existing institutional contexts all remain in need of further consideration. We've also seen growing pushback, both on the island and internationally, against holistic and in-depth approaches to dealing with the past. In 2023, Taoiseach Micheál Martin was quoted as saying, "We need to have an honest debate in terms of how far back do we go and how much do we pay in terms of wrongs of the 20th century." And in that conversation, he spoke of a dichotomy between meeting the needs of present citizens and meeting the needs of those related to non-recent abuse. It's an incredibly false and pernicious dichotomy because, of course, survivors remain citizens of the Irish Republic or other jurisdictions remain rights holders, and the harms that happen to them remain continuing human rights violations. So the sense in which they are past is negligible at best. Ireland is not unique in pushing back against a holistic addressing of past violence. We've seen the UK Overseas Operation Act in 2021 and the obvious Legacy Act more recently. We've seen apologetics around the British Empire and the Rhodes Must Fall movement, and we've seen the banning of critical race theory across several jurisdictions in the United States. Similarly, in Australia, Sarah Maddison and others caution about the limited nature of truth recovery that doesn't address the structural injustices of settler colonialism. And Elizabeth Stanley, writing about New Zealand's Royal Commission of Inquiry into Abuse and Care, notes again the pattern of deflection from state agencies. Stanley says, state agencies have constructed and organised narratives in complex and interactive ways to deflect criticism, resecure impunity and ensure the continuing legitimacy of the state. Crucial to this has been the omission or suppression of unfavourable knowledge and the destruction of records with poor investigations and a claim that all abuse is in the past. So, nice uplifting presentation for you after lunch. The book that was mentioned by way of introduction tries to get a context for what Anglophone nations have been doing in addressing the past. It looks at the countries you see listed there and considers 90-odd inquiries, 100-odd apologies, 40 redress or reparation schemes and existing litigation and reconciliation policies related to non-recent institutional abuses or historical abuses, and tries to assess those through a transitional justice framework. What we see, I think, is that countries in the Anglophone world spend a lot of money, typically on lawyers, addressing allegations of non-recent institutional abuses through the justice responses of inquiry, litigation, redress and apology. They pay limited attention or emphasis on the role of victim-survivor rights or their role as rights holders, preferring to frame things as questions of political benevolence, history or other non-legally binding frameworks. And the practice to date has been highly siloed in nature, dividing non-recent institutional abuses of church and state into discrete institutional contexts or related to distinct offences, primarily child sexual abuse. And the practice for survivors has been very damaging. We've seen very defensive and adversarial legal and policy engagements across a range of jurisdictions. So having gathered that perspective, I was interested in trying to understand why. Why across different countries and different settings do we see this posture that lots of money is spent, lots of publicity can be given to these institutional responses, but satisfaction and validation of survivors and their meeting of their other justice needs remains very, very low. What we saw is a pattern of ambivalence at best. Inquiries raise expectations for survivors that their other justice needs will be met, and those other mechanisms then struggle to deal with both the non-recent nature of the harm and the widespread and systemic nature and context in which it took place. And so I conclude that transitional justice mechanisms remain essentially capable of being captured by state interests, of being manipulated against survivor interests, and of being consistent with existing distributions of power and authority in society. And what seems to be more pernicious is that the institutional mechanisms legitimate themselves through survivor participation, through survivor giving of testimony, through survivor engagement with these processes, but not with concerning themselves overly with the positive experiences of survivors in those contexts. And so it's in that context then that I moved to look at the function of power. Now, there's probably as many conceptions of power as there are people in the room. And if we're playing Foucault bingo, we can throw him in here as well. So for the purposes of the book, I wanted something that was going to synthesize some of that literature without looking to complete it or claim mastery over it. And I was drawn to Mark Howgard's in Galway's work that combines different traditions of the power literature across these four axes. So power as an experience of agency, the use of violence, or the use of money, or the use of institutional authority. power in the terms of your structures, whether legal, institutional, theological or policy, power in the epistemic sense, related to people's experiences of being believed, their capacity to exercise voice and be validated, and power at that more abstract or vague sense, power relating to national identity, to governmentality, and to national and religious myth-making. And I think these dimensions of power are appropriate because they offer an analytical framework for addressing both the nature of non-recent institutional abuses, but also how power is manifesting in justice responses to date. So to take a sort of paradigm of the institutional abuse context, the abuse of a child within a closed institutional context, power is operating at a variety of levels. There is the use of power in the physical or sexual abuse of the child or other forms of abuse that inquiries have examined at a literal or factual or forensic level. There's a structural abuse of power that the organisation or institution was created or designed in such a way or was neglectfully managed in such a way that it placed the child in a position of risk with particular vulnerability or exposure to abuse. There's the ongoing difficulties in believing survivors, particularly children, in allegations of sexual abuse that can function as a form of epistemic injustice. And in particular contexts, the way in which the child is framed as a subject and conceptualised could be anything from framing them as moral dirt to framing them as inferior based on race or gender or some intersectional combination of the above. So power was doing some good analytical work in clarifying how and comparing how different forms of non-recent institutional abuses occurred and existed across diverse jurisdictions. But it was also doing work for me in trying to understand what was going wrong with the justice responses. So reparations or redress, the payment of compensation or access to psychosocial services, was intended to be a form of individual empowerment, that survivors would access these services, either be financially benefited or benefited in psychosocial ways, but oftentimes the processes by which these mechanisms are delivered depend upon legal representation or engagement with a bureaucracy that offered a practice against that form of empowerment. Redress and reparations often are limited in their capacity to challenge structural injustices. They exist as monetary payments and are divorced from questions of distributive justice or questions of access to land for First Nations or Indigenous peoples. Reparations have also functioned as a site of epistemic injustice, where even well-intentioned administrative policies have failed to address survivors' need for voice, survivors' need for validation and engagement. There's a quote related to the Canadian Indigenous Schools Redress Scheme, where one of those administering the scheme spoke about a paper-based application that was going to be a very banal application form that was covered front to back by survivor testimony of their experience, because there was no box, no space for that in the bureaucratic form. And the participant said, I didn't know what to do with that, which is both tragic and wholly damaging to survivors. So even seemingly straightforward processes functioning as sites of epistemic injustice. And finally, reparations typically are not rights-based, so they fail to recognise that survivors had rights at the times at which the abuses took place, that those rights were violated, and that the state and non-state actors owe them a duty to acknowledge that and to engage in a process of repair. Instead, reparations tend to function as benevolence, as ex gratia, and as something that equates the monetary value of the compensation with the worth of the survivor experience. And so the consequence of this, or how I tried to finish the book last year, was to call for vigilance. There's no reason to think that we can institutionally design our way out of this limit of justice when facing non-recent institutional abuses. Looking at power and the potential for it to subvert the best of advocacy, the justice needs and public support for non-recent institutional abuses suggests the need for constant vigilance in scrutinising and assessing state or church-led processes. Based on the past experience in Ireland and comparatively, victim survivors would not be wise to rely on the virtue or the good offices of state or church officials to fulfil their promises or commitments. An ongoing lack of trust, an ongoing working to remedy that is both legitimate and warranted. There's no reason to suggest a particular configuration of design could avoid co-option or the reconsolidation of power, and it's foreseeable that the actors who benefit from existing power structures will always seek to reassert that distribution of power when it is challenged on an episodic or individualised basis. So I kind of finished on a downer, and I was trying not to do that with the book, but it was unavoidable. But I feel as scholars we retain an obligation not merely to try and describe mechanisms that prescribe the good, but also to consider how we can expand policy, legal, academic and activist understandings of the possible as well. What can be done knowing what we know about the limitations that we see to date. And so I want to spend the rest of my time today speaking about how to take this vigilance and this scrutiny and consider it in the context of victim survivor participation in justice responses, particularly in the context of co-design. So Phil and Maeve engaged in significant and innovative work working with and on behalf of survivors to offer a new approach to addressing the context of mother and baby homes and Magdalen laundries in Northern Ireland. And their Truth Recovery Design Panel document speaks about the need for a victim survivor-centred, trauma-informed and human rights-based approach with a particular focus on the central involvement of and accountability to victim survivors and relatives for both the proposed independent panel and the statutory inquiry. The work of the independent panel is ongoing, and I remain hopeful that the insights offered by my colleagues here can be fulfilled in the inquiry panel's work and in the ultimate statutory inquiry that exists. But the comparative experience and the experience on the island to date does caution us to scrutinise closely how co-design's potential can be fulfilled. I'd be hopeful that it can operate as a signal for a new way that can be taken up on the island more broadly. We see the move towards a public inquiry rather than the commission of investigation, for instance, in the context of the Defence Forces, and a scoping inquiry model for abuse in day schools. So the more of the same won't work and isn't working. But beyond that, we have to see whether and how new approaches are meaningful for survivors. To do this and to consider how participation should be best understood, I looked at the transitional justice literature that has often provided the need for victim survivor participation as sort of a basic tenet, but has been very limited in implementing it, an aspiration rather than reality. And Patricia Lundy's work, and indeed her own activist research, has been valuable in identifying that survivor participation works best when it is a co-generative dialogue that results in transfers of power in decision-making processes. What we see in analysing co-design in other settings, however, is that the quality of the co-design and the quality of the participation is one of the key factors to assess in this regard. So Furco and Salem suggest in transitional justice there has been a preoccupation with greater participation rather than more meaningful participation, and participation models may not convey the complexity, the notions of power, agency, space and engagement that affect survivors and their communities. And so to try and analyse what more meaningful participation in these mechanisms might look like, I draw on work by Michelle Farr, who takes Hogarth's approach to the conceptions of power and applies them in the context of co-design of public policy. She says power can be positive, where both parties benefit from its exercise and can be productive and transformative and capable of compatible with dignity. So the co-design model may be empowering in the ways that I have found other mechanisms of transitional justice not to be. However, the social interactions, the people involved, and the structures within which these processes are all exist will influence the power relations and whether co-design will empower or embed existing power inequalities. And so Farr applies the four Hogarth elements: power as agency, power as structure in which participation occurs, power at an epistemic level, and power at the level of identity or outcomes to consider co-design in public engagement. A close evaluation, therefore, of how co-design processes operate and what outcomes they reach are key to assessing the legitimacy and value of these processes in justice terms. And comparative experience, again with co-design, suggests the need for this vigilance. Michael Dillon, in the context of Australia, considered how can co-design effectively operate in a context of ongoing power asymmetry and an imbalance in negotiation strength. And in the context of addressing First Nations and Indigenous people, how to ensure a diversity of voices and range of experiences are reflected in the process, and queries whether co-design can effectively address both incremental change and structural reform. The Australian context reminds us that contests about the distribution of power will be keenly fought. The defeat last year of the Indigenous voice to Parliament shows structural and ideological opposition to empowerment is a real and tangible risk. Similar experiences in Canada that you can see listed there. So to begin concluding, transitional justice and mechanisms that are designed to address the past seek to destabilise and challenge existing power dynamics and structures in the service of the rights and interests and needs of victims and survivors. And in doing so, it seems foreseeable and almost inevitable that the structures and dynamics that are being challenged will attempt to reassert themselves and align the nature of justice responses with their interests. Farr says adopting co-design and co-production techniques offers no guarantee of equal partnerships that will be enabled between staff and service users, or between survivors and the state, or survivors and the church. Constant, critical, reflective practice and dialogue is essential to facilitate relational processes that empower and enable. And so for the promises of co-design to be realised, they need to be combined, I believe, with broader and more radical structural reforms that offer survivors the means to exercise their rights, not just in policy terms, but also in legal and political terms as well. Thank you very much for your attention today. Appreciate it.
Thank you very much, James, for really interesting presentation. It certainly raised a lot of thoughts and questions, I think, in all of our minds. And thank you so much for sticking immaculately to the time, which has set the standard here. I'd like to welcome now Maeve O'Rourke, and Maeve is lecturer in human rights at the Irish Centre for Human Rights, School of Law, University of Galway. Maeve has authored and edited a lot of publications which focus on the rights of victim survivors of gross and systematic human rights violations, and also writing about truth, justice, reparation and guarantees of non-recurrence. In 2021, Maeve was appointed as a member of a 3-person independent truth recovery design panel to design a framework for a state investigation into Northern Ireland's Magdalene mother and baby and workhouse institutions. And she's a volunteer member of Justice for Magdalene's research group and co-director of the CLAN project. So very wide range of experience here. So thank you very much, Maeve.
Thank you. I chose the words, "I can't testify without my records," for the title of my presentation because they are now a clear and constant message from people affected by Ireland's history and present-day impacts of institutional and family separation abuse, who are preparing now to participate in the state investigation into Northern Ireland's mother and baby, Magdalene, and workhouse institutions and their related pathways and practices. Not only did Phil and I hear about the importance of access to records and archives from almost every single person, if not every single person, who interacted with our independent Truth Recovery Design panel in 2021, but I also heard these words, "I can't testify without my records," more recently from affected people who are regularly providing input to the 10-person independent panel of investigation, which includes 3 people with personal experience of the system under investigation. And I suppose, in paraphrasing, I am actually doing insufficient justice to the additional demand for access to the administrative archives, which I'll come on to discuss. It's really important that these words are being said so clearly and so frequently now. The chorus of people who have felt this way and said so but were ignored in the past includes those confronted with their own records only when they were on the witness stand of the Hart Inquiry, and who are now having difficulty accessing the Hart Inquiry's archive as a whole. That is the investigation in Northern Ireland into historical child institutional abuse. It's a sentiment shared by women who still cannot access the archive of state papers gathered by the McAleese Committee to establish the facts of state involvement with the Magdalen laundries in the Republic of Ireland, bearing in mind also that this archive doesn't even contain the nuns' records because the committee sent them back and destroyed its copies at the end of its work in 2013. The point is also made and was made by those who participated in the Clan project, which is a collaboration I set up in 2015 with Claire McGettrick, through which 60 solicitors in Hogan Lovel's London office helped more than 80 people give witness statements to the Republic of Ireland's Mother and Baby Homes Commission of Investigation, which, as I'll go on to explain, operated without disclosing one shred of documentation to the people affected, despite ongoing representations by Hogan Lovel's solicitors and us in the Clan project, including after the introduction of GDPR in 2018. And with colleagues including James, here, Phil, Mairead Enright, Sinead Ring, and our late great friend Vicky Conway, I've questioned how the forthcoming tomb exhumation process could be legislated for without including provisions requiring the disclosure to relatives of all records that could shed light on their family member's fate, including its context, and therefore all available administrative records as well as personal files. The refusal of numerous previous inquiries to give the very people affected access to the evidence under consideration, let alone to actively find out what information they were still unable to access and to help them obtain it, let alone to publish the evidence to the world at large to the maximum extent possible. This is probably what I find most disturbing about the tradition of state investigation into Ireland's institutional and family separation system, which involved, among other gross and systematic human rights abuses, the grave and continuing crime of enforced disappearance, which arises from lack of access to information following abduction or detention with state knowledge and involvement. The denial of access to the investigation archives during and after investigations is the hallmark, I think, of the practice of dislocating survivors of these abuses from the ordinary justice system, because we are told they are vulnerable. That these inquiries have been presided over and participated in by lawyers, even judges, who understand fair procedures and the importance of the public administration of justice in the ordinary course of their business is, I think, quite concerning. Not only does this secrecy convey to those affected that they do not have rights, either procedurally or substantively in relation to the past and present, that the inquiry needs to respect, but the hoovering up and withholding of records from them, at least in the Republic of Ireland, as I've researched, actively prevents them from accessing ordinary accountability mechanisms such as the civil courts, or pressing for inquests or criminal investigations, therefore portraying the abuse as not qualifying for such a response, which cements the notion that these inquiries are instead a way of dealing with annoying or potentially dangerous, while vulnerable, people. Or to quote Minister for Justice Alan Shatter's memo to government in late 2010 when advising on the establishment of the McAleese Committee to strengthen the position of the government in dealing with the ongoing campaign. In 2021, as James has explained, Phil and I and Deirdre Mahan had the honour of working with more than 100 people affected by Northern Ireland's Mother and Baby, Magdalen and Workhouse institutions on the adoption system, to recommend the framework for the now beginning state investigation, which will progress from an independent panel to a public inquiry. The core of our recommendations was information disclosure, primarily to those affected themselves, including relatives of the deceased, but also to the public to the maximum extent possible while protecting individuals' rights, and crucially, with a view to creating a permanent national repository that will educate future generations while continuing in perpetuity to provide access to those affected as a priority. An urgent recommendation we made was for emergency legislation to require preservation and to criminally prohibit destruction of any and all records, relevant records, wherever they are held. And in March 2022, as the last act before its mandate ended, the Stormont Assembly unanimously passed the Preservation of Documents (Historical Institutions Act Northern Ireland 2022. And there's an ongoing call for similar emergency legislation in the Republic of Ireland. According to the now ongoing independent panel's interim report, which they published last month, significant quantities of records have now been delivered by private organisations, including religious congregations, to PRONI, the Public Records Office of Northern Ireland, without powers of compulsion, which the independent panel does not have, but prompted, according to the archivists, by that emergency preservation legislation. It's an ongoing process, and the key questions of whether everything has or will be transferred and what access then the independent panel will provide, and what roles the public inquiry will need to play in ensuring outstanding production and disclosure remain to be answered. And at the same time, in the Republic of Ireland, due to a huge and long-standing public pressure campaign involving survivors of all forms of institutional and family separation abuse, the government is at last making plans for a national centre for research and remembrance at the site of the last Magdalen laundry to close in the Republic of Ireland at Sean McDermott Street in Dublin 1. And this national centre will include an annex of the National Archives of Ireland, as well as an annex of the National Museum of Ireland and Universal Design Social Housing and a Community Education Institute. Those of us involved in the successful campaign for the National Centre in Dublin were galvanised in particular by Dublin City Council's plan in 2018 to sell the Sean McDermott Street site to a budget hotel chain. This was the summer the Pope came to Dublin and travelled down Sean McDermott Street, stopping off at the church opposite the Magdalen laundry, but not meeting one single Magdalen or mother and baby home survivor. We were motivated also by Dr. Mark Cohen's discovery that summer, along with James, of decades' worth of financial records in the derelict Donnybrook Magdalen laundry, which had not been turned over to the MacLeese Committee and which showed extremely substantial money-making. We were further motivated by our voluntary convening of 147 Magdalen survivors in Dublin for the Dublin Honours Magdalens listening exercise in summer 2018, at which the women were unanimous that they wish future generations to be educated fully about the abuse. Then, in 2019, the government produced the Retention of Records Bill, which would have sealed for at least the next 75 years, including from survivors themselves, every single document currently in the dormant archives, i.e. inaccessible archives of the Commission to Inquire into Child Abuse, the Residential Institutions Redress Board and the Residential Institutions Redress Review Committee. The pressure we felt to obtain a resolution to this situation and our efforts to do so increased when in late 2020 the Minister for Children announced that he would seal entirely the archive of the Mother and Baby Homes Commission of Investigation after receiving it. Furthermore, for years I had been trying to access the state records contained in the MacLeese archive on the Magdalen laundries. A survivor and pro bono lawyers obtained an Information Commissioner decision saying that indeed the archive was held for the purposes of freedom of information, but I was not allowed access thereafter because I was told the costs of searching it exceeded those permissible under freedom of information. So now, happily, in 2024, we have sister national historical care-related records repositories under imminent construction. And there are complex and wide-ranging questions that need to be answered, and that could now be answered on an all-island basis, with those affected to the forefront regarding how the repositories should operate. I should note, of course, that the building of specialised repositories should under no circumstances delay the implementation of existing law, such as GDPR, which applies to all data holders whose behaviour the states should be supervising, freedom of information, and government departments' obligations to deposit in the National Archives of Ireland. Ensuring implementation of existing data laws is crucial in view of the abuses at issue and the age of many people affected, but also, going back to my previous point about victim survivors' dislocation from ordinary justice in the democratic state, because it establishes that these records are not in a league of their own, they're not a radioactive substance, and those who have been denied them have been discriminated against for far too long. At a day-long event last week at the Royal Irish Academy entitled Archives, Access and Human Rights, I discussed some of the key human rights norms that will need explicitly to underpin both the actions of the ongoing Northern Irish investigation process and the legislation to underpin the Sean McDermott Street Annex of the National Archives of Ireland and potentially future legislation for its sister institution that will be permanent in Northern Ireland. The right to identity is, of course, essential. The European Court of Human Rights has established that this right is part of the Article 8 ECHR right to respect for private and family life. And according to the court, states must provide people with information about their family origins and about their treatment as a person in state care. And in 2020, the Irish Court of Appeal recognised as an unenumerated Irish constitutional right the right to have one's identity correctly recognised by the state. And to reach this conclusion, the court drew on the concept of human dignity, which is a founding principle of the Irish Constitution, and also referred to European data protection law, which again is based on the notion of human dignity in the sense of being enabled to determine one's own ends and being treated as an individual and as an equal to all others. You might, some of you, be aware that GDPR has actually come to the rescue of survivors and adopted people in the Republic of Ireland since it came into force in 2018. It prohibits blanket barriers to accessing personal data and has been essential, therefore, to rejecting the Retention of Records Bill that I explained and to challenging the Minister for Justice's plans to seal entirely the Mother and Baby Homes Commission archive. He is now accepting and responding to personal data access requests. Under GDPR as well, it's not permissible to restrict data subject rights in ways that are not necessary and proportionate. And this principle has enabled, or did enable, Claire McGettrick and those of us advocating alongside her to repeal the 2016 Adoption Information and Tracing Bill, which would have made it a condition of receiving your name at birth that you would undertake never to contact your parents or attempt to do so. To comply with GDPR, the ongoing investigation in Northern Ireland and the National Centre in the Republic will need to ensure data security and will need to protect living individuals' rights to know and be notified about what personal data is held on them, to have access to their personal data, to rectify inaccuracies and supplement gaps, and to object and request erasure depending on the circumstances, while bearing in mind that GDPR does allow for archiving in the public interest and therefore for restriction of certain rights, such as the right to object or to erasure, were absolutely necessary in the pursuit of the public interest. I would argue the National Centre legislation should state explicitly that the public interest the archive is pursuing is the protection of human rights and the remedying of human rights violations. And there are comparative examples to follow, and a number of us here have worked with staff of the Stasi Records archive in Germany to understand how that institution proceeds in accordance with GDPR and in pursuit of human rights. The absolutely core data protection principle that must be respected, simple as it is that information relating to people who were institutionalised or adopted or abused in related systems is their personal data. Where other people are mentioned in records, such as people in charge, and this information relates to the survivor or adopted person, this is also the survivor or adopted person's personal data. The Court of Justice of the European Union has been clear that information can relate to more than one person at the same time, and this does not affect its quality, as each person's personal data to which the ordinary rights apply. It's also too frequently forgotten or ignored by those who still redact and refuse survivors and adopted people's records that the deceased do not have rights under GDPR which can counteract those of the living. In addition to personal data rights, it's crucial that the National Centre in the future and the ongoing Northern Irish process address the rights of relatives of the disappeared. Relatives' rights to know the fate and burial place of their babies, their mothers, their siblings, their aunts and uncles, and people's right to know the circumstances in which they were separated from family and their family members were separated from them. These are rights that the National Centre will need to fulfil. And of course they are rights, as I said, that the state should already be fulfilling in order to bring enforced disappearances to an end. And that brings me also to the comprehensive right to truth, justice, reparation, memorialisation and guarantees of non-recurrence. They together make up the right to an effective remedy that victims and survivors of gross and systematic human rights violations have under international law, and they're also for the benefit of society at large. They are the pillars of transitional justice, and none of them is possible without access to information, not just disclosure of personal data or of relatives' fate, but crucially also disclosure of the administrative archives and other sources of information that reveal the system through which people were abused. Survivors and adopted people's right to participate in the public disclosure of the truth is paramount in European and international human rights law. In general, the European Court has found under Article 10 ECHR that, and I quote, it is an integral part of freedom of expression to seek historical truth. Close quote. The state's refusal to allow individual access to documentary sources for legitimate historical research can violate the right to freedom of expression, according to the Strasbourg Court, as freedom of expression includes freedom to seek as well as to impart information. Freedom of expression will be an extremely important right when it comes to drafting new legislation for the National Centre. I've argued previously with others that the norm, including as it's protected in the Irish Constitution, requires the repeal of previous gagging clauses in the Residential Institutions Redress Act and in the 2004 Commissions of Investigation Act, which purport to prohibit survivors from speaking publicly of the detail of what they told the investigation and redress bodies. I also think Article 10 ECHR requires positive measures to assist people in putting their own accounts and experiences and their responses to the archive on the public record, if that is what they wish. The Strasbourg Court has found in previous case law that Article 10 imposes a positive obligation on states to create a favourable environment for participation in public debate by all concerned. But specifically in the context of investigations, the European Court has been very clear about victims' entitlement to access the evidence under consideration in its jurisprudence on the meaning of an effective investigation under Articles 2 and 3 ECHR, among others. And I want to dwell on this because I think it's important to consider that the inquiry archives amassed to date should not have been gathered in secret, and they should not therefore be allowed to stay as they are. Two wrongs do not make a right. Via new legislation for the National Centre for Research and Remembrance, and this might also be something to consider in relation to the Hart Inquiry Archive in Northern Ireland, the previous inquiry archives should be deposited and opened to the extent possible while protecting individuals' rights, and they should sit equally alongside all other relevant religious, state and non-state records and archives that the National Centre requires, ideally with the benefit of emergency legislation to require preservation and prohibit destruction, as was passed in 2022 in Northern Ireland. I only have time to go into the Mother and Baby Homes Commission of Investigations operations, but I have written elsewhere about other inquiries and their Irish legal frameworks. In addition to European human rights law having required maximum possible disclosure to survivors, which did not happen, I've actually found that the inquiry's own Irish legal underpinnings both required more access than was given and certainly did not mandate the level of secrecy imposed. In October 2020, the Mother and Baby Homes Commission of Investigation delivered its final report, having gathered an archive of testimony and records that it did not share at all with institutional survivors or adopted people or the public at large during the 6 years of its investigation. Over several years, Hogan Lovells, on behalf of the Clan Project, requested that survivors and adopted people be enabled to hear and see the evidence of the religious, state and other representatives whose testimony and records might affect them. We reminded the Commission of its obligation under Section 12 of the Commissions of Investigation Act 2004 to disclose to a person who gives evidence to a commission, which of course included survivors, and I quote, the substance of any evidence in its possession that, in its opinion, the person should be aware of for the purposes of the evidence that person may give or has given to the Commission, close quote. Section 12 of the 2004 Act, meanwhile, gave the Commission discretion to hold public hearings, for example, of institutional and state representatives, where the Commission was, and I quote, satisfied that it is desirable in the interests of both the investigation and fair procedures to hear all or part of the evidence of a witness in public, close quote. The Commission refused to hold any public hearings and refused to publish or give survivors or adopted people any of the evidence it was gathering. The Commission actually refused people access to their own records even after GDPR came in 2018 and refused mothers information it held about their deceased babies. Several survivors, including Philomena Lee, with the assistance of Hogan Lovells, requested permission to give their evidence in public. The Commission refused, even though Section 11.1 of the 2004 Act expressly allows evidence to be heard in public at the request of a witness, or, as I already mentioned, if the Commission believes doing so is in the interests of the investigation and fair procedures. The Commission did inform Hogan Lovells that people could come and view a transcript of their investigation committee testimony in the Commission's premises, but individuals were not permitted to have a copy. This made it impossible, really, for people to check the accuracy of the Commission's record or respond, and it turned out, when the Commission's report was published, that the Commission had destroyed the audio recordings of 550 people's confidential committee interviews without seeking permission, without giving prior warning, and without making full transcripts. And it was only following an extremely stressful and significant public pressure campaign that the Minister for Children forced the Commission to obtain backup tapes that are now available on a subject access request. 5 months after the Commission's report was published, former Commissioner, Professor Mary Daly, explained at an Oxford University seminar online that the Commission had fully implemented the religious and other alleged wrongdoers' rights to see and comment on the evidence under consideration. Professor Daly explained, and I quote, if we wrote something that was adverse, critical about an individual or an entity, an institution, we had to write a draft report where we made these critical observations and supply them with the accompanying documentation. And they had a chance to read that and they had a chance to come back. They came back with a vengeance. By this point in time, mid-2021, 8 women, mainly clan witnesses, who had given written testimony to the Commission and kept their copy, had brought High Court judicial review proceedings against the Minister for Children standing in for the now dissolved Commission. The Government agreed to High Court declarations that the Commission breached the survivors' statutory rights as individuals who were identifiable, even if not named, to comment on the draft findings relating to them. And the Government agreed to append to the Commission's report a notice of all findings which the survivors would have challenged as inaccurate reflections of their testimony had they been given a chance. These findings include the Commission's conclusions that the nature of the violence suffered by boarded-out children, quote, cannot be established. Women, quote, were not incarcerated in mother and baby institutions. There is, quote, no evidence of women being denied full, free and informed consent to their child's separation from them. And there is, quote, very little evidence of physical abuse. So now the Minister for Children holds the Mother and Baby Homes Commission archive. He has said he must seal it for 30 years according to the 2004 Act, although the Attorney General's advice as to why precisely is of course not public. But at the same time, the Minister is accepting data subject access requests due to GDPR, and in late 2020 he introduced 2 further changes to the archival arrangement under the 2004 Act through new legislation. First, his legislation allowed the Commission to give an entire database and all underlying records of mothers and children to TUSLA, the Child and Family Agency. And second, his legislation required the Commission to ask survivors whether they would like their confidential committee testimony, now of course retrieved with backup tapes, redacted before it went to the Minister, and 80 of 550 people opted for this. So what I would say is this experience goes to show that it is, of course, possible to amend the arrangements under which the existing inquiry archives are managed. More needs to be done. Lots could be done now while we wait for the National Centre to take shape. Lessons can certainly be learned from how the Northern Ireland investigation proceeds from here on out. And of course, requests may come from the independent panel and the future public inquiry in Northern Ireland for the Irish state to assist, and interesting questions arise there under the European Convention on Human Rights, which we mentioned in our Truth Recovery Design Panel report. So thank you so much for paying attention, and I look forward to discussions afterwards.
Thank you very much, Maeve, for what was just a brilliant account of such a long struggle for survivors to try to get access to what should be basic human rights. And for me, the paper brought together so well the need for research to be action-focused and to make people's lives better, because otherwise what is research about, really? So it's an absolute privilege to introduce my very dear friend and colleague, Phil Scraton, who I'm sure most of you here know. Phil's one of the founding members of this Irish North-South Conference, and really good to have him here. So Phil is, is Professor Emeritus in the School of Law at Queen's University and has held visiting professorships all around the world, in Sydney, Australia, Auckland, New Zealand, Amherst, USA. He currently holds a Leverhulme Research Fellowship. Most of us here will have read some, if not all, of Phil's 17 books. I think some of us have read them all, Phil, self-included. And those include Law, Order and the Authoritarian State, Childhood in Crisis, Power Conflict and Criminalisation, The Violence of Incarceration, Hillsborough the Truth, and the forthcoming Childhood Transition and Justice. Phil was primary author of the Hillsborough Independent Panel's groundbreaking report, Hillsborough 2012, and co-author of pioneering research into the circumstances of the 76 to 81 H Block and Armagh prison protests. He's also written on the experiences of victims, survivors and mother and baby homes and Magdalen laundries, as well as police brutality at the 2022 Paris European Champions League final. And I have to say, as soon as I heard about the violence at that final, I thought Phil's going to be onto this, and you straight away were, and doing really important research on that. Phil was awarded the Freedom of the City of Liverpool in recognition, quite right recognition of his Hillsborough research. In 2017, he was cast away on BBC's Desert Island Discs, but fortunately for us, isn't actually cast away. And full respect to Phil for having refused an OBE, which to me is a better honour than the getting of the honour. So, hand you over to Phil.
In the words of a colleague in the School of Law, it's all downhill from here. They were great presentations. Thank you so much. None of us is an island. None of this work can be done by an individual. It's always a collective. And if the spirit of this conference has anything, it is how we can come together to develop new work, important work, critical work. And I think from listening to Maeve and James and the presentations this morning, I think we can actually see that and identify with it immediately. Some of you will be familiar with this image. It's a child being taken from the sea in the Mediterranean. And I'm not a poet, but somehow these words came out as the sea withdrew on its twice daily ebb, golden Mediterranean sands speckled with washed up cargo, not for bounty hunters nor trophy seekers, but body bags and unmarked graves. From this well of suffering and fractured lives, politicians seized a callous opportunity. When we first came here 21 years ago, we soon became aware of the death of Annie Kelly in prison, and I became directly involved in that case. And I just want to pay tribute to her. This was her final note. At the end of the day, I know that if anything happens to me, there'll be an investigation. I ripped the mattress or blanket. I never ripped the mattress nor blanket, nor did I block the spy. She means the spy hole of the cell. So if I take pneumonia, it'll all come out. I think you can only last 10 to 12 days without drinking, because then you dehydrate and your kidneys go. I've no intention of eating or drinking again. So they're beat there. I know they'll all love me dead, but I make sure everything is revealed first. I never met Annie, obviously, but I was doing research with Linda in the prison at that time. And the family gave us this, her last letter home. I've not altered it at all. It's in her own spelling. And it brings home very directly the suffering that goes on behind the wall of jails. Let me introduce you to Eddie Spirit. He's holding a photograph of his son in his hands, and he's talking about the last moments that he was with his son. It's on the terrace at Hillsborough, as the crush came like a vice getting tighter and tighter. I turned Adam round to me in distress. There was a police officer on the track about 5 or 6 feet away. I begged him to open the gate, screaming, "My lovely son is dying," begging him to help. He just stood and looked at me. I punched the fence. Right at the beginning, when I was begging the officer to open the gate, I could have got Adam out. And now the crucial words. I know, because I was there. Eddie himself was left for dead and recovered under a blanket, having been left for dead. He became a very close friend, and he died a few years ago with the early onset of Alzheimer's. And this is another friend. Mick, we were taken into the staff room. Some parents' names were being called out. Those of us left behind thought, It's probably their children who've been killed. We weren't told anything. The police behaviour was atrocious, as if we were an inconvenience. Eventually we went in, he started talking, knowing nothing about my family, said, "Mr. and Mrs. North." I stopped him and said, "I'm a single parent." His wife had died 3 months earlier. "I'm a single parent, and this is my friend who stayed with me. And this is his daughter who died in Dublin." On my knees, 8 months pregnant, scrubbing a clean floor, holding my belly with one hand, the brush with the other, the nun standing over me a few days after she was born. They told me to dress her, gave me new clothes. They took her. She was gone. I lay there looking at the empty cot, holding her blanket to my face. As a man, I can't pretend to know what that emotion feels like. As a father, I can get fairly close. And another of the statements, I have lived with this silently all my life, and I've felt like I've carried a heavy burden, a heavy, guilty burden. These are the voices of the bereaved and survivors that encapsulate the work that I've done over the years. Deaths in police and prison custody, which continues. Stardust in Dublin, as you know, is ongoing. Lockerbie in Scotland. Hillsborough, Marchioness, Dunblane, Grenfell Tower. Regretfully, but also certainly to my benefit in terms of interpersonal relationships, I met so many wonderful people, but I wish I hadn't, because I wish these events had never occurred. And of course, as you've just heard so eloquently from Maeve, the mother and baby institutions and Magdalen laundries. I wasn't sure what to present today or what to talk about today, and I didn't really want it to be about me. You see what I try to do in my work. What to do with knowledge of faraway suffering? It seems normal to ignore the ordeals of others. We don't get it. We can't imagine how dreadful, how terrifying. Can't understand, can't imagine. Perhaps the only people with the right to look at images of suffering of this extreme order are those who could do something to alleviate it. I understand what Susan Sontag is saying in this wonderful short book, but I also am not too sure about the conclusion. I feel an obligation not to look at images of suffering, but to try and understand suffering, to try and engage with suffering, because it's through that engagement that I feel I get closer to the truth. What do we mean when we say we know something? How do we know what we know? Sounds like a 101 philosophy course question. It's not. It's a profound question. When Henry Reynolds was appointed as a teacher from Tasmania and he went to work in Australia, he went to Queensland and he went down to a cell. He was told, go to the prison, the local prison attached to the police station, a small place where people were held on remand. And he went down and he went into one of the cells, and there were two young Aboriginal children standing there in tatty dresses, filthy, a mattress on the floor, broken glass from the window all around them. What are they doing here? What have they done that is so bad? They'd been sent by their teacher because they'd been misbehaving in class 1966, an important year in Australian history. He asked the question, why weren't we told? That became the question of his first book. How do we know what information is reliable? What do we mean by scientific analysis? And we've just heard in that discussion the complexity from James of power, the dimensions of power he talked about. And taking that on board, agency, structure, epistemic, ontological, power in its rawest sense is always mitigated by ideology, how we see power, how we understand power, what power means to us. But if I take the Foucault notion of regimes of truth, it's when power transforms into a regime of truth, that it becomes influential, dominant. John Berger talks of ways of seeing, as the artist going and looking in an exhibition, sees so many wonderful paintings, some abstract. He always says it doesn't matter even if the painting is a constable, it's obvious. He says the way we see it is the way we see it. It's inside us. It's in our histories. But how do we see the issues we're talking about today? How do we understand them? How does the general population come to an understanding? And of course, in this, one of the issues that I want to contest is the way of seeing that is factual, objective, straightforward. Because in terms of how ways of seeing are constructed around so-called scientific analysis, there is intellectual collusion. We work in an establishment where intellectual collusion is commonplace. So what of dissenting accounts, what we've been hearing about today, alternative discourses? For me, to create an understanding of dissenting accounts, to try and work on building alternative discourse, we need to be there. We need to be inside it. That's why I started by paying tribute to those witness statements. We need to bear witness. And in doing that, taking the lead from Sivanandan, we should turn cases into issues, because we're creating here a view from below. We're endorsing a view from below. We're breaking the silence, bearing witness, hearing testimonies, recovering truth, in inverted commas, whose truth? Challenging the deceit of official discourse, and to turn, as C. Wright Mills said all those years ago, to turn personal troubles, and we all have them, we all share them, to turn those personal troubles into public issues. And we do that through hearing, researching, working with personal experiences, placing them in their social and cultural histories, understanding them through an in-depth knowledge of the political and economic context in which those histories and experiences are shaped. And if I can steal another concept from the great French feminist Frigga Haag, German feminist Frigga Haag, doing memory work. Memory work means we have to work at memory. We have to understand memory. We have to interpret it. And, as I'll be coming to in a second, how we then memorialize the truth, the understanding that we find en route. But there are ethical challenges in being there and bearing witness. As I've written elsewhere, such research requires being there and bearing witness and occasionally taking the research into a different place. And I looked to Don McCullin, a brilliant war photographer. He was saying, confronted with a child in Vietnam, when do you put the camera down and do something? How many times do we hear that issue of, I felt I failed because I couldn't intervene? When do you pause as a researcher and directly intervene? Give evidence or expose what is happening before it is too late. I've never forgotten being called out of a class halfway through a talk with my students and having to rush to court to give evidence in a death in custody. I couldn't say, I'm in my scruff. I don't have any other clothes anyway. I couldn't say, I'm in my scruff. I couldn't say, I'm teaching class. I'm too busy. Researching deaths in controversial circumstances institutional negligence and interpersonal violence. That presents political as well as methodological and ethical challenges. How do we deal with them? Because critical social research is not an academic exercise. It's an activist's exercise because it's about disclosure. Yes, we lose our track with the various funding bodies that we have to satisfy, with the various restraints and constraints they place on our academic freedom. But critical social research is about disclosure. It's concerned with context, moments, events, responses, consequences, placed within their structural determinants. Personal troubles, as C. Wright Mills talked, understood and explained within prevailing social, political, and historical inequalities. We can never dodge inequalities. They surround us at every moment. We're aware of them at every juncture. Class, gender, sexuality, race, age, ability. And as Stan Cohen says, or said, it's about troubling recognitions. How do we reclaim meaning and the significance of issues that have been denied by formal techniques of denial and neutralization? I'm not simply talking here about media, I'm talking here about academic research in particular. Disclosure and dissemination of troubling information, then, is the responsibility of the critical researcher in creating an alternative discourse. The work I was talking about earlier couldn't be done without an alternative discourse, without an alternative way of seeing, without putting yourself in the position of those individuals, those families, their experiences. It's about truth recovery. In the North here, we hear a lot about those two words, truth recovery. But what does recovering truth actually mean? When we're dealing with institutional failures in investigations and in due process, the failures of criminal investigations, the failures of inquiries, how many inquests I have sat through where I have watched the reality of a death or deaths being distorted, being fought over by a range of different, very well-paid lawyers representing different institutions, often against a family's lawyer, one lawyer, without legal aid. It's hard to believe, isn't it, that the death of an individual in contested circumstances actually comes down to funding. And of course, the avoidance of liability. In Hillsborough, finally, at the second inquests just in 2016, it was interesting when they realized that the funded this time families, the fully represented families, after 2 years of an inquest were winning the case, they turned on each other. They started to blame each other, the blameless authorities who'd so long stood united, turned against each other. Families and survivors' campaigns are at the centre of this. What a privilege it is for me to have worked with so many families and so many survivors in a situation where I would just wish I wasn't there because I wished that their losses had not happened. But independent research, whatever the funding restrictions people have in universities, and of course I understand it, independent research is absolutely essential. Building historical context, putting immediate circumstances into that historical context, and then considering the aftermath, what happened next. We can see that in Grenfell Tower, but we can also see that in Ballymurphy here in Belfast. And you've already heard Maeve talking about the significance of independent panels and state public inquiries. People say to me, oh, you were on the Truth Recovery Design Panel. What was that like? And I say it was really tough. But my goodness, I worked with people who had such a real influence on making sure that the women particularly, but also the men, who came and gave their evidence were well represented, that their truth, after all these years, were out and that they could walk through the streets with their heads up instead of down. And Maeve has already mentioned, and James, the significance of redress, reparation, apologies and memorialisation. Redress, what does that really mean? We have to ask that question. Reparation, are we only talking about financial reparation? Do apologies just simply slip easy off the tongues of politicians who weren't there at that time and who can put distance between them? And what does memorialisation mean? Both my sons live in the city that has been dominated, and rightly so, by memorialisation. Berlin. But what does memorialisation mean? Is it a tourist attraction? Or is it something that really means to the community forever? What those apologies, it is part of that redress. And building a permanent truth archive in all of these situations, once we access the material, what still exists is so significant. So, knowing and memorialising, what I'm talking about is bearing witness to survivors' and relatives' testimonies, accessing and archiving records, ensuring that survivors and relatives have primacy of access. And in doing this, goodness me, we have enough words written, we have enough articles, we have enough standards to know that investigating human rights violations in institutional practices, the actual words are there on the page. It's about activating them. It's about ensuring that they are put into operation. And through that, we hold state and non-state institutions and individuals involved to account. You know, one of the things that's really interesting is the amount of people who've suffered so much who say to me, actually, Phil, I don't want to see anybody go to jail. What I want is truth, acknowledgement. What I want is for people to be held to account, and be held to account in the court of public knowledge, not opinion. As my partner Dina and I have written previously, securing rights and justice requires a fundamental shift in structural relations and what we call the determining contexts of power, which marginalise and exclude from effective participation. And some of you will have seen this next slide before. I can't better its words. Ariel Dorfman summed it up so well in the aftermath of the colonel's coup in Chile and his own expulsion and the death of so many of his friends and relatives. They found a way of speaking out, the men and women whose voices have now reached us, decided that they could not live with themselves if they did nothing. They could not stain their lives by remaining silent. They understood that if they witnessed this suffering inflicted on themselves or others and did nothing, they were, in some twisted way, being turned into accomplices. They had to face the long nights when it seemed nobody cared, when the darkness of apathy seemed to surround them when their voices did not seem to receive the echo and the answer they needed. We, with our skills, with our knowledge, our understanding, with our inquiring minds, as you've heard from both James and Maeve, it's about standing in that position. It is about coming together and forming a coalition of inquiring minds. Because it's not necessarily, and I know there will be people in the room who have suffered and endured, but it's not necessarily us who have been through those processes. But we do have the skills, the articulation, the understanding to come alongside, never to take over, to come alongside those who have suffered the most, and to ensure that if justice means anything, it comes in the truth of their experiences.